Good afternoon, everyone, and welcome to today's installment, the final installment of our ongoing series Toward a More Perfect Union. My name is Samuel Holliday, and I have the pleasure of serving as Director of Operations and Scholarship for the United States Capitol Historical Society. And we're so grateful that so many of you have taken time out of your busy days to join us as we explore these important topics and have these important discussions. Before we get started with today's program, I'd like to go over just a few technical housekeeping matters of how we like to use this Zoom webinar platform to engage with you, our audience. If you have any questions throughout the presentation for Professor Rosenbaum, you can submit them through the Q&A section of the webinar platform. It looks like two little speech bubbles, either at the top or bottom of your screen, depending on what device you're using to join us today. If you have any technical troubleshooting matters, if you feel like you're having difficulty hearing what we're saying or seeing us, you can submit any technical issues through the chat function. I'll be keeping an eye on the chat section and answering in real time. But once again, any questions for Professor Rosenbaum can go into the Q&A section of the webinar platform. It's now also my great pleasure to introduce the President and CEO of the United States Capitol Historical Society, Jane Campbell, to start our program. Jane?
Thank you, Sam, and thank you for all the work that you do to bring these webinars to our folks. Today is the final segment of our multi-month series on Toward a More Perfect Union. For those of you who've been following along, we really have focused on the importance of the central tenets and values of this country. And amazing, the founders of our country, yes, they were mostly men. Yes, they were all white who wrote the Constitution and the Declaration of Independence. Some of them even owned enslaved people. Nevertheless, they wrote a document that called for equality, that called for justice, and we have been working hard for the nearly 250 years that our country has been alive to live up to those standards. Today, we have the opportunity to hear from Professor Carrie Rosenbaum. And Professor Rosenbaum will be talking with us about immigration in the 20th and 21st centuries. If you think about the arc of history, of how in the Constitution itself, it didn't speak to immigration, but it did speak to naturalization. And in the early days of our country, the immigration laws were made by the states. Eventually, the federal government took a leadership role, although Professor Rosenbaum will share with us some of the issues that are going on even today, where some of the states are starting to create their own perspectives on immigration and how does all that fit together. So we are honored to have Carrie Rosenbaum with us today. She's an attorney. She serves as a law professor and a scholar. She has been a law professor at the University of Berkeley and at Golden Gate, and her work focuses on the intersection between immigration law, criminal employment, and constitutional law. She has played leadership roles in the American Immigration Lawyers Association. She serves as a consultant to lawyers who are engaged in complex immigration litigation, particularly regarding the consequences of criminal convictions, terrorism, persecution, and other accusations, and how political asylum fits into this. LexisNexis publishes her work and has recognized her as an expert commentator. And so we are honored to have this expert commentator here for a conversation. Professor Rosenbaum has agreed that she's going to talk and invites you to join in Q&A. So as we move forward, I will be monitoring the Q&A, and as she talks, I may periodically interrupt her and say, our listeners are concerned about blah, blah, blah. So if we have a little bit of back and forth, that is our way. We're going to allow you to participate and encourage you to participate in the conversation. So Professor Rosenbaum, thank you for being with us. Thank you for taking your time. I know where you are, it is early morning. So Good morning, and thank you for joining us. Tell us what we need to know.
Thank you so much for that warm welcome, Jane. I would like to thank the United States Capitol Historical Society for inviting me to participate in this important series toward a more perfect union. I'm also grateful to the founders and sustainers of this organization, a true treasure, preserving congressional history and providing opportunities not only to celebrate it, but also to examine it and learn from the past. Special thanks to Sam Holliday and Jane Campbell, as well as to those of you in the audience for participating. I look forward to sharing thoughts with you today on US immigration law with a focus on diversity, equity, and inclusion. And I will also be sort of noting if Jane looks like she wants to share a question, so please, by all means, do use that Q&A. I don't need to be a talking head this morning or afternoon. You're welcome to engage with me throughout. So first, in a presentation about immigration law, inherently about land, rights, and sovereignty, it's important for me to recognize that where I work and live within the UC Berkeley community is on the ancestral and unceded Ohlone or Native American land. Immigration law is the focus of my teaching, scholarship, and legal work, as Jane said. Specifically, my scholarship explores the relationship between criminal and immigration law, or what scholar Juliet Stumpf at Lewis and Clark Law School coined as crimmigration law, which is the convergence of criminal and immigration law. Just a real quick word about immigration terminology, one word in particular. When I use the word non-citizen, I'm referring to anyone who is not a United States citizen. You might think that that sounds obvious and it's clear who's included in that bucket. Of course, immigration law is notoriously complex, so it's not as obvious as you might think. A non-citizen can include a person who is undocumented, either by way of overstaying a visa or entering the US without permission. A non-citizen can also be someone who's authorized to stay temporarily, like a tourist, or a non-immigrant worker, like the tech workers here in the Bay Area on H-1Bs, as well as students and the folks who have sort of the highest degree of status before they become a citizen, those who are lawful permanent residents. So again, a non-citizen, when I use that term, can refer to anyone in those categories. If at any time in my presentation I neglect to define a term or you have a question, as I mentioned, please do use the Q&A. So in talking about crimmigration and race, it's helpful to zoom out and consider some broader questions. So as a part of this discussion, I'll be implicitly exploring questions like John F. Kennedy's proclamation that we're a nation of immigrants, and contrasting that with the idea of some scholars and historians who contend that perhaps we're a settler state. Can both be true? Can the US be a settler state and a nation of immigrants? Are colonizers migrants? And why does this question matter? Harvard anthropologist Mahmoud Mamdani observed that settlers are made by conquest, not just by immigration. If we say we're a nation of immigrants, what does that implicate for Indigenous people or American Indians? Indigenous scholar Joanne Barker has observed that Indians enters the national imaginary as a racialized subject rather than as a foreigner, only after and because Indigenous sovereignty has been extinguished by the settler state. So she says, the erasure of the sovereign is the racialization of the Indian. I thought that was an interesting idea. The erasure of the sovereign is the racialization of the Indian, because it's very similar to how many of us in my field look at immigration law, that there are ways in which immigration law and the making of the immigrant and the way the immigrant is constructed also involves a form of racialization. Non-citizen racial minorities are treated as outsiders and outside of the national community and have been subject to cruelties not unlike those endured by Native Americans and forced migrants from Africa, or enslaved or formerly enslaved persons. The treatment of aliens, as they're referred to in the Immigration and Nationality Act, or undocumented persons in the US, particularly those of color, has paralleled US domestic race relations in a way that is often and easily overlooked. So today we will consider the relationship between the nation's origin, the construction of race and immigration law, with a focus on the emergence of crimmigration within the past 20 to 30 years. So first, it's hard to understand the relationship between immigration law and race without going back to the initial conquest and establishment of the United States. I'll start there briefly, just touching on the idea of settler colonialism. It's a burgeoning field in academia around the world and has recently been brought into the field of immigration law to help explore immigration problems. And then I'll explore the role of crimmigration in undermining the promise of democratic equality for all persons in the United States. And I'll explain what I mean by that. Settler colonial theory suggests that the early colonists of North America came not simply to exploit its land, labor, or natural resources, and then return to their mother country, but to settle permanently. And as a part of that process, exercise sovereignty over the territories that they occupied. A settler colonialist has been described as one who comes with an intent to stay rather than to return home in a distant land, and one who sees or saw oneself as a founder of a political order with an entitlement to a preordained sovereign claim. And this is not necessarily just something that refers to the past. A settler colonialist is different from a colonialist in that sense, and that settler colonialism continues. So settler colonialists came or come in some instances and settled, and after determining themselves to be legitimate inhabitants, claimed a sovereign prerogative to decide, and here's the where we start talking about thinking about immigration, who may enter and live within the state's borders. So these new inhabitants then ensured that rights and obligations of citizenship from the earliest moments could be afforded primarily to a European minority. The political system and infrastructure they design reflects this and informs our immigration system in ways still relevant today. The US has had a complicated history with welcoming and excluding immigrants, and this is related to that same history. As historian May Nye and critical race theorist Ian Haney-Lopez have shown us, immigration law and policy have been used to manufacture race. What I mean by race in this context is that it's a social construct defining insiders and outsiders, or groups of people deemed worthy of welcoming, and those characterized as inferior and necessitating exclusion. Race is often seen in fixed terms, either as a biological given or a static social category. However, as Haney-Lopez, author of White by Law, notes, the debates about race at the turn of the century demonstrate that racial categorization is a fluid process that turns not only on prejudice, but also on factors ranging from dubious science, there he's referring to eugenics, and to national honor. The first Congress of the United States, as many of you probably know a lot about, perhaps even more than me, in 1790, used the Naturalization Act to enact Citizenship Law, defining as eligible any alien being a free white person. The court then struggled to determine who was and who was not a white person. Their reasoning relied on eugenics and something that became coined as common knowledge to determine who was and was not white, and therefore fit to become a US citizen. For the lawyers in the audience and those who've studied law, reading these cases and the decisions is really just incredibly striking to think that not precedent, not a legitimate science, not the Constitution or any other basis, but just the idea of common knowledge could be a rationale for deciding something as important as who could be a United States citizen and what their categorization should be as far as race. So the case law demonstrated that the court's rationale was results-oriented, somewhat unsurprisingly. It shifted in reliance on one set of criteria over another, eugenics, common knowledge, precedent, to come to the preferred result. Today, even if state action does not preference based on race, a racial hierarchy nevertheless persists. The social construction of race and immigration law has also occurred through the Chinese Exclusion Act of the 19th century and the creation of the Asiatic Barred Zone, which I know was discussed in the last presentation in this wonderful series. The 1924 national origin quotas as well, which were in place until 1965. Policies influenced by labor needs, like the dehumanizing and exploitative bracero program of the 1940s and 1950s, as well as mass deportation programs targeting or disproportionately burdening particular ethnic groups or persons of particular national origins, like the repatriation of Mexican nationals in the 1930s or Operation Wetback in 1954, including United States citizens at times of Mexican ancestry or descent. Mexican workers who entered without inspection, as you probably know, were derogatorily called wetbacks, replaced now with the term illegals or illegal aliens. And they were accused by many of displacing American workers, depressing wages for all workers, and increasing racial discrimination against Americans of Mexican descent. And they were also, without support or any sort of data, accused of being criminals. Professor Bill Ong-Hing has said, the structure of immigration law has institutionalized a set of values that dehumanize, demonize, and criminalize immigrants of color, which is, as I would suggest, and many of you might agree, at odds with the democratic promise of equality. More recently, race-neutral immigration policies and what Ming-Soo Chen describes as colorblind nationalism hide discrimination and colorblind or race-neutral state action. Two examples, just briefly: the travel ban under the prior administration, barring immigration from Muslim-majority countries, absent evidence of a national security threat, and the mass incarceration of migrants fleeing Mexico and Central America in search of safe haven in the US. In the travel ban case, the court expressly overturned the Korematsu case, which had authorized imprisonment or internment of Japanese nationals, including US citizens. However, at the same time, the court conceded that the policy was potentially overbroad, and the policy in the travel ban was potentially overbroad and did little to serve national security interests. However, still found it to be a legitimate government interest outweighing the right for that group of persons to be free from discrimination. So this is part of the settler colonial trajectory. There's a relationship between racism, white nationalism, and bias against immigrants of color, as well as US citizens of color. The treatment of particular racialized groups pervades political and social life, creating a perception that all people, for example, of Mexican descent or Latinx persons, all people of Middle Eastern descent are permanent foreigners and people of color. Maynai calls this the alien citizen idea. Just as the tide ebbed and flowed between welcoming and excluding, efforts to grapple with race have done the same in the context of immigration law as far as progress and stagnation. Congress and the executive have had moments of racial reckoning in immigration law. On the heels of the Civil Rights and Voting Rights Act in 1965, Congress repealed the national origin quotas, recognizing that differential treatment was incompatible with democratic values. So the 1965 Act barred racial considerations from expressly entering decisions about immigrant visas. However, in the years after World War II, as the proportion of Spanish speakers in the US increased, nativism was evidenced by a negative response to that trend. The Blue Ribbon US Select Commission on Immigration and Refugee Policy stated that the US was far from free from prejudice. Prejudice against dark-skinned people remained strong at that time.
Professor Rosenbaum,
Yeah.
we have a couple questions from our listeners,
Okay.
and it sort of fits into this context of how we deal with people of different races. So how would the process differ now for individuals who have, say, comparable education, a 24-year-old male with a high school degree who's coming from the United Kingdom or Ecuador or Ukraine? I mean, are there different for those three, or would it just really be at this point the same no matter where you came from?
So if I understand correctly, is the question, does the law expressly discriminate on the basis of race or national origin for example, someone from the Ukraine versus Mexico or Norway?
Right.
No, the law does not expressly discriminate, but as I'm describing, it's the way in which this history has informed the law. And an immigration law, national origin, can serve as a proxy for race. And it's less about necessarily what's written into the law. And sort of like I referenced, Ming-Hsu Chen wrote an excellent article I'm happy to refer people to in the Yale Regulatory Journal online, called Colorblind Nationalism, sort of describing this phenomenon. It's similar to the way in which the discrimination used to be very clear and on the face of a law, like the Chinese Exclusion Act said, we are going to bar Chinese nationals. We think that Chinese people are a bad race. That's not a direct quote, but that's the idea. And in fact, the language was much more insidious than that. And so then we saw, not necessarily an immigration law, that's a topic for an entire different day, but we saw equal protection come in when there was discrimination on the face of a law. And the court said, okay, well, legislators, you're expressly discriminating against a particular group in this legislation, in this law, you can't do that. The Equal Protection Act does not allow you to do that. So then what changed, and what I've written about more recently, and I'm happy to refer folks to that work, is the way in which, and many others have written about this before me as well, the way in which the discrimination happens is now through other means that's not direct and not express. And we see racially disparate impacts. So the way particular groups are impacted is more significant than others. But the way the law has evolved, it's that much harder, unfortunately, to do something about that. So if that is a sufficient answer.
And so when you talk about the disparate impact, can you give some examples so that
I will be actually.
Oh, you've
so
got that coming up.
I will get to that.
We will let that go. All right, go for it. All right.
Super. Two of them, though, one of them would be that I will be talking about more is the use of immigration prisons at the southern border. That's a particular decision to use imprisonment when it hasn't historically been used, and I will be talking about this more. And that's had a disparate impact on Mexicans and Central Americans. So the 1965 change to the national origin quotas did result in increased immigration of immigrants of color to the US, but the act itself didn't eliminate racism in US immigration law, as I'm sure many of you can imagine. New facially neutral laws and policies, like I was just referring to, resulted in disparate impacts on non-citizens of color from developing nations. Part of this is through enforcement, which was and is still highly racialized. There's actually racial profiling that's allowed under the Constitution pursuant to Martinez-Huertas and other cases at the Supreme Court from the 70s. And the use of race in enforcement that would be unlawful in criminal law has been deemed constitutional in immigration law. So that's one partial answer to that question that we could spend hours on. The criminalization of immigrants and trends in the merging of criminal and immigration law, or crimmigration, are largely responsible for the furtherance of the insidious role of race in immigration law and policy, and importantly, are not confined to immigration law, meaning if we care about equality throughout our country, it's important that it exists as well in our immigration policies. So the legal landscape changed, flashing forward to the 1980s, with respect to the Immigration and Nationality Act in ways that more deeply entrench the role of race in immigration law. The ensuing crimmigration controls employed criminal law as a response to migration, bringing with it the racial bias that has been documented to be certainly longstanding and in place in criminal law, and reinforcing the myth of criminality steeped in racism and nativism. And for those who might not be aware of this, the empirical data has demonstrated that non-citizens are in fact less likely to commit crimes than their native born counterparts. So I'll just sort of touch on some concepts with respect to the 1980s and 1990s reforms, and then some specifics. So the use of detention as a means of policing immigration law and deterring migration sort of began in the 1980s. The militarization of the border occurred around that time, as well as heightened interior enforcement and cooperation between state and local police and federal law enforcement agents, with lots of documentation, unfortunately, of racial profiling infecting that. Elimination of relief, meaning those who had pathways to fight their deportation and stay with their families and earn a right to stay, that was removed. The elimination of immigration judges to exercise discretion to consider equities and keep families together, that was a part of the 1996 reforms. There was a massive increase in removals and deportations, including many persons deeply committed to American values who perceive themselves as American, but for that legal document, and had extensive ties here: businesses, homes, families, churches, communities, according to research by Beth Caldwell in a book I would highly recommend, Deported Americans. So federal prosecution increased as well, including arrest for immigration crimes that had been previously treated as civil immigration offenses. Within the past few decades, arrests for immigration crimes have grown faster than any other type of federal crime. Federal immigration crimes have come to be prosecuted at the same rate as federal drug crimes. An expanded list of crimes that can result in removal from the United States, even for long-time lawful permanent residents, or LPRs, as we call them in the field. There's also been increased enforcement of crimes that only apply to migrants, and using criminal prosecution, as I mentioned, instead of civil immigration prosecution. The 1986 Immigration Reform and Control Act under the Republican Reagan administration did create the last and most recent path to lawful status for the undocumented, but also brought with it significantly increased punishment and prosecution of existing crimes of unauthorized entry, so that means just someone who enters without permission, and re-entry, as well as document fraud. 1986 law made it a crime to hire unauthorized workers, smuggle people, or help people enter the US without permission, including one's own family members, and marrying solely for an immigration benefit. The 1996 Clinton administration moved the Democrats to from a more nuanced approach to sort of a more tough on crime or law and order stance with respect to immigration, in addition to criminal law. They signed two major pieces of legislation with sweeping criminalizing effects for non-citizens: the 1996 Illegal Immigration Reform and Immigrant Responsibility Act, and the Anti-Terrorism and Effective Death Penalty Act. An entire course could be taught just on that legislation. It did many things. In part, it criminalized false claims to US citizenship, which one can make inadvertently by marking the wrong box on an application for a loan to buy a house to a lender. It also criminalized voting in a federal election and helping prepare false immigration applications, which are even, in fact, strict liability offenses. And an example of this, I actually have a case now of a lawful permanent resident who came here with her mother from the Philippines at age 2. She came as a lawful permanent resident. She and her mother and her sister and her brothers all had green cards, as well as her father. Her mom worked as a nurse for her whole life, and she and her siblings made it through the public education system with some bullying and, racial insults that they had to endure. But she was incredibly persistent and persevered and embracing her vision of the American dream. And she's incredibly successful working in the tech industry in the Bay Area. She's married to a US citizen. working on starting a family, and her mother had a stroke not long ago, and she takes care of her mother and her house and handles everything for her. However, she was convinced that it was her duty when she was in college to register to vote and vote, because people who enlist people or encourage people to vote in voter registration drives, including at the Department of Motor Vehicles, do not know and do not understand who can and cannot vote, and they like to get people registered to vote. Can't tell you how many times I've heard of this happening, where innocent people naively think. Another client of mine actually thought she was enrolling in like a registry, because in other countries like the census, the voter registration is really a registry just to tell the government who you are and where you live. So this client did understand that she was a lawful permanent resident. She thought she was not allowed to vote. She told everyone that. She registered. She thought to herself, well, if I get a notice back saying you're not allowed to vote, that means that I'm not allowed to vote. Well, she got something back saying you're registered to vote, go vote. And she did. And now she cannot pursue becoming a United States citizen because of that innocent mistake, unless she wants to risk being deported from the country, separated from her mother, her husband, having to start all over. So that's just one of the ways in which, some of these changes have potentially made a criminal out of someone who's otherwise an incredibly law-abiding person, and who, for all intents and purposes, feels like a United States citizen, even though she knows she's not. So these laws also expanded crimes that IIRA and EDPA that qualified as aggravated felonies, subjecting non-citizens, including permanent residents, to deportation. So the aggravated felony definition, it sounds like a really terrible crime if someone commits an aggravated felony. It actually includes misdemeanors. That definition was expanded to approximately 20 pages. It's incredibly long, complex, and convoluted. And that if someone has been convicted of an aggravated felony, if an immigration judge decides that, it's all but impossible for them to fight removal, both to prove their offense is not an aggravated felony, and particularly without appointed counsel. People who are fighting deportation are not entitled to counsel the way they would be if they were fighting a criminal sentence, although the Supreme Court has said many, many decades ago that the punishment of deportation is like permanent banishment and is a very serious and severe penalty. If the court finds a lawful permanent resident has been convicted of an aggravated felony, that person cannot secure relief from deportation, with the limited exception of Convention Against Torture Relief, which has an incredibly high bar. And I know and remember and will never forget, because one of my first cases in court was for a woman who was a lawful permanent resident and unfortunately suffered the permanent deportation and will never be able to come back, and had to leave with her US citizen kids and be separated from her family. Just as the war on crime ensnared low-level offenders and not drug kingpins, IIRA and the criminal grounds of removal and inadmissibility have led to the deportation of green card holders and others who might have had a legal right to stay, but for those minor offenses. So
Professor,
also,
We've got a couple questions. Going back to one of the things you were talking about, the southern border. And one of our listeners posed a query that the activities on the southern border are a matter of geography, and that, their question is the concern about crossing the border at the southern border, the people who can cross are Hispanic, because that's where the border is. And the Norwegians are not walking across the border. Is there a difference between our northern border and our southern border, and
absolutely,
how does that play out?
And I've written about that. Well, so when a Norwegian flies here and overstays a visa, they don't get arrested and put in immigration jail. The point is that the decision to use imprisonment for someone who, well, and in this case, I just also want to clarify, I think there's maybe a misunderstanding there. I see the question is, aren't the problems on the southern border not of race, but of geography? Which it would be quite convenient, right? Given that Norwegians cannot walk into the United States, ethnicity seems to be a correlation more than a cause. And virtually everyone able to walk across the southern border is Latino, Hispanic. So first of all, no one can walk across the border. Anyone can go to a land port of entry to attempt to enter. But if someone tries to enter at the southern border and they don't have, and I'll be getting to this later in the talk, and I hope they'll make sure we save time to get to that. But if someone attempts to enter the United States and doesn't have a visa, they approach Customs and Border Protection, and they've been saying, I am fleeing persecution and harm in my country. I'm fleeing torture, violence, gangs. They killed my family. The government has arrested my whomever because they protested, because they want a democratic government. So that's who has been showing up on the southern border. And historically, it gets a little bit murky, but things radically changed under the most recent administration, the Trump administration, in that there's a process called expedited removal. And that is also selectively chosen to be used at the southern border, not at San Francisco International Airport when a European comes to enter, which you can't even get on an airplane if you don't have a visa. So that's like an entirely different set of questions. But if someone comes to a port of entry and says, I'm fleeing harm, I'm seeking protection, they are put into expedited removal proceedings, which means they don't get to see a judge. They have to prove that they have what's called a credible fear of returning to their home country. And if they pass that test, they don't get deported, they don't get sent back, they're allowed into the country, and they're put in immigration jail immediately. So there is a very big difference in the treatment of those two borders. Okay. I want to make sure I get to that in more detail at the right place in the talk. So I'll sort of keep going, because we're just about at that point, actually. I kind of want to set the stage for that and help frame it a bit better. So detention was not actually used as a means to enforce immigration law until more recently. It was rarely used and was the exception until the 1980s. It was an outgrowth of the increasingly harsh penal norms that had gained popularity in the 1980s war on drugs. And immigration detention is also called detention and not prison or jail, which is what I and many others refer to it as, because within the civil immigration system, immigration law is not supposed to be a punishment. There's not supposed to be any kind of punitive aspect, because it's civil immigration law. And so there are fewer rights as far as due process protections, because you're not being punished. However, for all intents and purposes, if any of you have seen, the news, if you believe what you see on TV, which, at times is very real, there have been families, children, mothers, fathers, people who could be, someone's brother that you might know, who have been locked in these really outrageous conditions that Human Rights Watch and international organizations have broadly condemned, where people have died at historic rates. There's abuse, neglect. Anyhow, we'll talk about that more, but they're referred to as detention centers and facilities, and they're certainly no picnic. They are prisons for all intents and purposes. They quite literally in every way. So the first time that immigration prisons were used kind of more expansively in immigration law to deter migrants or to address migration was asylum seekers in the 1980s who were interdicted at sea. And in a case called Jean v. Nelson, critics alleged that the Haitian interdictions at sea were motivated by race on the basis of African ancestry or heritage, but effectuated via the proxy of alienage, meaning their unlawful status, and immigration status. So in Jean v. Nelson, the 11th Circuit considered an equal protection challenge on this basis, but they struck it down finding that excludable aliens, so people who were not entitled to enter the country, were also not entitled to equal protection under the Fifth Amendment in the context of immigration law. The Supreme Court had in other cases determined that an alienage law, like a county ordinance that discriminated on the basis of alienage, could be struck down on equal protection grounds, but that immigration law was not subject to the same restrictions, largely because the Supreme Court has determined through a doctrine called the Plenary Power Doctrine that immigration law is exceptional and Congress should have great authority and the executive in making immigration law. And so there are compromises made to individual rights and some of our liberties and freedoms and values that would not be permissible in other areas of law. So the Circuit Court in John v. Nelson rationalized the national origin discrimination, again, on this basis of plenary power or the government's complete authority over immigration law. It's not often referenced directly now, but some suggest that the outcome in the Trump v. Hawaii travel ban case is still influenced by plenary power, even though some would say, well, on the other hand, the court did entertain the question at all, which suggests not a complete deference to Congress. So immigration prisons. By 2001, there were over 200,000 persons in immigration prisons each year while waiting for a decision in the removal case. So this is like pretrial detention. That more than doubled to over 400,000 by 2011, and it's over 500,000 today. In 2014, Congress created a bed mandate of 34,000 non-citizens a day, effectively guaranteeing at least that many people would be detained each day. The average daily population is now over 50,000 at a cost of $125 to $325 a day. And again, these are for individuals who have not necessarily committed crimes other than asking for permission to enter the country, or in some cases, if they have committed a crime, it might have been the crime of entering without permission. These numbers do incorporate both interior enforcement, so ICE and CBP at their Customs and Border Protection at the border. There's a $3.2 billion budget allocated for this kind of enforcement and use of immigration prisons. So as I had mentioned, abuse is rampant in these immigration prisons, including accusations and evidence of forced sterilizations of women who did not know that they were being sterilized, medical neglect, and violence against imprisoned children. There's one particularly facially race and national origin neutral immigration statute, which this is what I was referring to earlier and said I would get to, part of the 1996 reforms that's really responsible for this over-detention of asylum seekers at the border. So Immigration and Nationality Act, Section 235, passed and implemented in 1996, created this expedited removal statute. It's used at the border to deport quickly without a hearing or a judge. There's no due process. And it authorizes, as a matter of discretion, generally by Customs and Border Protection, to detain or imprison someone throughout that process. It empowered particularly Customs and Border Protection to more easily and rapidly detain and deport non-citizens who present themselves at the border, even when they're requesting humanitarian protection. And as a former asylum officer who's sort of seen what these asylum claims look like and also seen reports from Customs and Border Protection and ICE officers, the data and information out there that there are times where Customs and Border Protection and ICE is focus on law enforcement can exceed the bounds of the law. I would testify under oath to the fact that I can affirm that there is some truth to that. There's also a history of Customs and Border Protection, before it was Customs and Border Protection, at the earliest era and stages of our country of having Ku Klux Klan members who actually enforced our borders. And as I think, some may have heard with the recent concerns of the rise in white nationalism and the attacks on the Capitol, it's important to remember that law enforcement is not immune from individuals with pretty firm commitments to the idea of white nationalism and a white state. And there could be more done to prevent that from happening and prevent that from impacting law enforcement in a way that makes it unlawful at the very least. So INA 235, a non-citizen in immigration prison can only secure an immigration court hearing if they express that fear of returning to their country, and an asylum officer or Customs and Border Protection officer, beginning under the Trump administration, determines that they have a credible fear. If the Department of Homeland Security finds they have a credible fear, then it's up to Customs and Border Protection to decide if they will grant release on parole or keep them in custody. And as I said, in recent years, the decision has been sort of a one-way exercise of discretion. It's effectively no discretion other than discretion to say, you will stay in immigration jail. Even if you have, are a woman who just fled incredible violence and sexual assault and barely got here with your life, you and whomever else will be detained and be in immigration jail until your hearing is complete. So the facially neutral statute, INA 235, particularly B1A, authorizes this discretionary detention or imprisonment of migrants at the southern border, and it disproportionately impacts those who are of Mexican and Central American descent or such migrants. As Elizabeth Cohen writes in her new book, Illegal, How America's Lawless Immigration Regime Threatens Us All, she writes, whatever one thinks about unauthorized immigration, a system that fails to ensure basic due process for people ensnared in immigration courts or deportation proceedings is a system grossly indifferent to a foundational principle of any democratic country. She was referring to unauthorized migration as well, not necessarily even asylum seekers fleeing violence abroad, subject to expedited removal, in spite of effectively doing things the right way by presenting themselves at the border and saying, I would like permission to apply for something to allow me to stay. Coinciding with an increase in migration from Mexico and Central America in 2013 and 2014, DHS under the Obama administration began to use immigration imprisonment specifically as a means of deterring migration. In 2015, a district court in RILR versus Johnson considered a challenge by mothers with minor children who had fled Honduras, Guatemala, and El Salvador, who had established that credible fear of persecution during expedited removal proceedings. They brought statutory and constitutional Fifth Amendment challenges to their detention while their asylum claims were processed. The court found that DHS indeed had a policy that directed ICE officers to consider deterrence of mass migration as a factor in custody determinations. So not whether this person is a flight risk, whether this person's a danger, but just can we potentially send a message of deterrence by putting this individual in jail now. The court also found that the policy played a significant role in the increased detention of Central American mothers and children and issued a preliminary injunction in their favor, stating that a large number of asylum-seeking families from Central America are currently being detained as a result of DHS's deterrence policy, and they also cited the harms of detention, especially to children. The court also noted that a general deterrence rationale seemed less applicable comparing to those described as pedophiles in a prior Supreme Court case or violent sexual offenders, because neither of those being detained, the mothers or children, or deterred were wrongdoers, but rather individuals who may have legitimate claims to asylum in the country. The court's rationale included this consideration and also sort of evoked the justification that the government had used and referenced the idea that in barring Chinese migrants during the Chinese Exclusion Act era, the government relied on an inappropriate rationale. The court said, defendants have not conjured up the specter of an influx overwhelming the country's borders or wreaking havoc in southwestern cities. The simple fact that increased migration takes up government resources cannot necessarily make its deterrence a matter of national security, with all the attendant deference such characterization entails. So the court was saying the people coming to the southern border from Central America and Mexico are not coming in such mass numbers and in a violent or challenging manner that there's actually a national security threat. And let's not pretend that that's what's happening when we all know it's not. The court also recognized that there was an implication that the DHS policy was improperly influenced or motivated by race. I would suggest that in creating immigration reform in coming years, rather than waiting for that equal protection challenge and hoping it succeeds, Congress could explore ways to amend the INA to decrease chances that immigration enforcement will be needlessly punitive and racialized, absent an actual national security threat, especially given we know there's this deep, extensive history of and potential for racially disparate impact. So in moving towards a more perfect union and revisiting our history, in order to build a more humane, less costly, and democratic immigration system that better reflects our equality-oriented underpinnings of our democracy, we might want to consider the invidious role of race throughout our nation's history and what it could mean to be a settler state with respect to immigration law. Historians, political theorists, and immigration scholars have argued that modern constitutional democracies are morally obligated, perhaps, to extend the option of full membership to all those whose identities have been substantially constituted through former colonial powers. Specifically, Tendaye Achiume at UCLA is one who's made these recommendations in an excellent article, I believe, called Decolonizing Migration. She suggests that, and others also suggest that, former colonial powers have an obligation to admit colonial subjects to compensate for the injustices of colonialism. And some of those ongoing harms have created and forced climate and economic migration. US immigration law may need to address the humanitarian and equity concerns implicated by those problems, climate and economic migration, as a matter of racial equity. As Congress contemplates future immigration reform, it could use an affirmative action approach, actively examining how immigration law has created and reinforced racial difference, and find ways to go beyond purging the law of expressed racial bias and move towards righting past wrongs, more of a restorative reparations-based approach. It could consider ways to address rights deficits of groups who have been subject to policies that were either expressly biased or had disparate impacts. Specifically, it could reintroduce a form of INA 212C, which is the portion of the Immigration and Nationality Act that was eliminated, but used to give immigration judges discretion in the deportation of lawful permanent residents with criminal histories, but who had demonstrated rehabilitation, substantial ties to the community, and equities. We could double down on family-based migration as a means of adhering to the commitment to family values and racial equity. We could consider the role of family migration in shoring up our economy by providing workers, whether grandparents who aren't technically compensated and care for children of some of those H-1B workers that I've represented, or family-based immigrants in pursuit of their own careers or filling other domestic labor needs. We don't need to necessarily view family-based migration as a drain on the economy. That's not, in fact, accurate. And wages don't need to undercut those of other workers. Instead, wages could be raised adequately so that new immigrants or other immigrants, whether documented or not, are not paid less than other native-born workers. So this is perhaps more of a labor than an immigration issue.
Professor Rosenbaum, we're sort of coming toward the end of our time.
We are.
And so two questions kind of combined as we come to the wrap. What nation would you suggest people look at where there is fair and democratic immigration policies? And are you in consultation with the Biden administration as they deal with immigration reform? Are you part of that discussion?
Those are great questions. I want to make a few points before I answer that. Sorry, let me just see sort of what parts are critical that I don't want to leave out. But yeah, I will try to get to that. Just some other quick notes on some suggestions for reform. The standard for civil immigration detention for those challenging removal could be revised to place the burden on the government to show that a migrant is a danger or flight risk, such that alternative means to protect the community are available. This would sort of bring things in line with the criminal standard for pretrial detention. Reduce federal sentences for illegal entry or decriminalize it. It's important to know that usually re-entry is to join family, and people will in fact do almost anything to reunite with family. Anytime I've been aware through colleagues or otherwise of someone who's gone back to, for example, Mexico, when they weren't here with permission in the first place, or if their status had run out, they went home to deal with a dying loved one, and then the rest of their family was here. And so the reentry was to rejoin them. So those prosecutions aren't targeting dangerous individuals who are harmful. We could also end mass adjudication of misdemeanor illegal entry at the southern border. That would be an act of racial equity, I propose, because such prosecutions disproportionately, again, burden Mexican nationals. Instead of waiting for a court, which courts have been grappling with this, to potentially find an equal protection violation, Congress could take affirmative action to address the racialized harm there. Those prosecutions have been ineffective in deterring migration and are costly, and could be, again, as they were in the past, dealt with through civil immigration sanctions. Just two last notes. You asked if I am working with the Biden administration. I'd say indirectly. I'm certainly happy to do so more directly. The Black Alliance for Just Immigration, however, is one group of advocates urging President Biden to include immigrants in a current pardon process that he is actually developing focused on racial equity. That group does work at the intersection of criminal and immigration legal systems and suggests that immigration is a racial justice issue that must be integrated into the administration's work on racial equity. So I think if we, continue to explore immigration law through the sometimes unflattering lens of history, we can be more effective in moving our union towards perfection and better living up to its promise of being an inclusive democratic union. So no, I don't know that I'm not a comparative scholar, so I focus on US immigration law. I don't think that there's necessarily, another system that could just sort of be placed into our world and solve all these problems. It's a lot more nuanced than that. Certainly there are some things that other countries might perhaps do better, and some things that we certainly do better still, absolutely. Some of the problems with the use of detention to deter migration and racialized harm exist throughout the world. And that's why looking at things from the standpoint of settler colonialism and looking at the relationships between those who are keeping people out and those who are seeking to flee places where they would certainly rather stay because they're their home, but they can't for whatever reason, makes a lot of sense to kind of examine those relationships on a broader scale, and not just from the standpoint of the United States. Yeah.
Well, Professor Rosenbaum, you certainly have a fascinating arc of the most recent history and how we've dealt with immigration, some of the questions of racial equity and criminalization, given everybody, I think, a lot to think about. We thank you so much for getting up early and joining us and sharing your thoughts and perspective. We are really appreciative of your taking the time to be with us. And for all of those of you who are on the webinar, thank you for joining us. We want to thank you for being with us during this entire More Perfect Union series. It is all of the videos will be on the website. And so if there's some that you missed that seem particularly interesting, they're available. You can catch them at your own convenience. Moving ahead, as we move into the summer months, on June 1st, we return to our lunch bite, our Tuesday lunch bites, where we have a scholar who's joining us, James Banner, who was educated at Yale and Columbia and has just written a book called The Ever-Changing Past: Why All History is Revisionist History. So we look forward to his perspective on that. And for those of you who have been following our incredible series with our chief tour guide and public historian, Steve Livengood, we return to the Cox corridors, the corridors that are in the Capitol that go to the House, painted by Alan Cox as commissioned by the United States Capitol Historical Society. And so on June 15th, we will be doing part 3 of the Cox corridors. We believe there are 4 parts, but what we've learned is that as Steve does an ever deep dive in his research, sometimes he finds more material than can fill into a time. So right now, we're telling you this is part 3 of 4, but there could be more. We'll see how it all plays out. Again, we thank you so much for your support of the Society, for your support of all the work that we do, not just these scholar series and the lunch bites, but our civic education, which is now available virtually and online. So any of you who know teachers who are interested in virtual resources to teach the Constitution, we have an enormous new resource with the We the People Constitution Tour virtual hub. Details to follow. We're thinking about even doing a lunch bite just on that to encourage people to understand how we've changed to accommodate the pandemic times and created a resource that can be used by people across the country. We thank you for your support. Thank you, Professor Rosenbaum, for being with us. Thank you, Sam Holliday, for putting this together. We look forward to seeing you again soon. Be well. Goodbye.